Welcome back to the channel, and please don't forget to subscribe if you are new to the channel. We upload videos regularly to make your immigration process easy. In this video, today we are going to talk about why your Form I-130 petition processing takes longer and what you should do to lessen this longer processing time. Let's get into the video. A Form I-130 petition for alien relative is a petition used by U.S. citizens and lawful permanent residents to ask the U.S. government to allow a family member to come and live in the U.S. with a green card. The form is filled with the United States Citizenship and Immigration Service, which is the immigration agency that handles all applications, includes the U.S. If a U.S. citizen or lawful permanent resident wants to bring his or her family member to the U.S., the Form I-130 is the first step in the process. The speed of Form I-130 processing depends on a number of factors. But to give you a rough idea, USCIS will process your Form I-130 petition faster when the relationship between the petitioner and the beneficiary is not a marriage. This is because immigration officials often do not recall an interview for non-marriage cases when both spouses are present in the US. To give you a rough idea of the time frame, an I-130 takes about 8 months to be approved. Let's know why. Why do your Form I-130 case status check show your case is still pending? Sometimes the Form I-130 takes longer than 8 months to be approved. There are several reasons for that. For starters, USCIS may be very busy and have longer than normal processing times. You can take a look at the USCIS processing times and see if your case is outside of normal processing time. Another issue could delay a case is USCIS does have all the evidence they need. For example, when a son or a daughter files an I-130 petition for a parent, they are required to submit a copy of the birth certificate to establish the relationship. But if they did not submit a complete, legible copy of the birth certificate, then USCIS will request another birth certificate, which slows down the I-130 processing. Other times, there is a problem with the discrepancy in names. For example, a son or daughter files an I-130 petition for a parent, but the name of the parent on the son or daughter's birth certificate does not match the name the parent is using on the petition. This may happen if a mistake on the birth certificate or if the child changed their last name after getting married. In the worst case scenario, a delay could be because the Form I-130 is stuck on someone's desk or because the file is lost or the beneficiary of the petition has past immigration history. For example, if you have previously been in removal proceedings, USCIS will need to get that file from the agencies that handled your deportation. The request of this file could delay the case. What can you do if your Form I-130 petition is pending for too long? If you think your case is taking too long here are some steps you can be taking. The first step is to check normal processing time for Form I-130 petitions. You can do so by checking the USCIS processing page. You will have to enter the form type I-130 and the location where it was filed. The location can be found at the bottom of the Notice of Action, I-797. Receipt notice. If you are still within normal processing time, then it is best to wait. If you are outside the normal processing time, then the next step is to file a request with USCIS online. In order to file this request, you will need all the information on the Notice of Action, I-797. Request notice. After you have submitted the request, you will get a confirmation number. USCIS will then send you an email telling you when you should expect a response from them. If the USCIS does not respond to your request within the time stated, or if you see no changes in the status of your I-130 petition, then you should call the USCIS hotline. It is helpful to have the confirmation from your online request. After you have tried the above, but nothing has changed with your I-130 case status, then you may consider hiring an experienced immigration attorney. Some, but not all, immigration attorneys are able to file lawsuits against the federal government, asking for the USCIS to make a decision on the I-130 petition because it has been pending for too long. A lawsuit like this is called a petition to right of mandamus, which is just a fancy way of referring to a lawsuit asking the government to take some action that it's supposed to take. Thank you for watching, and please subscribe to the latest update. Bye!